Attorney General.
Thank you very much, Madam Speaker. Madam Speaker, the contributions which have followed my opening the debate on this bill, I pay tribute to all of them. I think that they have been significant, and I in particular want to acknowledge some of the remarks that have supported the acclamation of this important piece of legislation that we are committed to passing this evening. I'm particularly, and I say this even though I have a smile on my face and I will allow myself a light tease, I am particularly pleased by the support, the fulsome and enthusiastic support of the Honourable Member for Diego Martin East. In particular, his acclamation of the fact that this legislation that we are hoping to pass this evening is significant in terms of the culture of alternative dispute resolution, the culture that we already embrace in this country as a mediation center, which we are continuing to build on. He has pointed me to some of the legislation out of the United Kingdom with respect to the adjudication center legislation, which I am going to put on my legislative agenda to come to the Parliament with in the new term. And there is this tease that I will allow myself, while I endorse the support of the member, to articulate, and it is that he spoke of expedition, which is one of the hallmarks of this particular piece of legislation. It is identified in the objects of the bill, and it is identified throughout. And in speaking of expedition, I just want to reassure the honourable member of the fact that he will appreciate, because this is something that I've had a conversation with him on, he will appreciate the huge significance in terms of protracted litigation to resolve commercial disputes. He will appreciate the huge significance of Section 56, subsection 3 of the bill before this House, clause 56, 3, which says, and I read it in its entirety for the record, fees charged and expenses incurred by any arbitrator or foreign representative in an international arbitration which lasts for a continuous period of 30 days or less in a period of 365 days shall be exempt from income tax and any other tax of Trinidad and Tobago. The significance of that clause in this passage, in this bill that we are about to pass into law, is that it gives a very real incentive to the most important players in the arbitration process to bring home the results of the dispute resolution in a period of 30 days or less. That is a significant incentive in a culture in which we have become accustomed to litigation, laboring through years of unresolved disputes. The idea that we are passing legislation now and giving a reward to persons who are going to function expeditiously and bring home the result of the litigation, the arbitration, in a period of 30 days or less in a calendar year of 365 days, I think bodes well for the quality of expedition that this legislation is going to bring to bear. Of course, he has made the point that there are precedents that we will have to continue to look at. There's a precedent out of Jamaica, there's a precedent out of the BVI, and we will have to continue to look at that as we tweak the legislation going forward. But I think we are making a very significant start with that first incentive to bring home the results in 30 days or less. I also want to pay particular tribute to the Honourable Member for Port of Spain North, who speaks from the authority of the portfolio that he holds as Minister of Energy and Energy Industries. Because in my pilot today, both here and in the other place, one of the areas that I identified as being an area of high specialization, particularly germane to Trinidad and Tobago and the historical growth and richness of our economy, is that we have always been, for as long as we can recall in our youthful memory, we have always been an energy-based industry, an energy-based economy. And therefore, the fact that we can now put onto our books, our law books, legislation that is going to enable us to offer to the investment sector in Trinidad and Tobago, from outside of Trinidad and Tobago, the fact that we have brought ourselves up to the 21st century in terms of our arbitral platform is significant. So I was very pleased to be able to have as one of our colleagues on the bench today on the government side, the Minister of Energy and Energy Industries, who was able to speak, and the figures that he's put on the table, a $9.2 billion US dollar direct foreign investment in gas upstream. That gives us a tangible example of the value of this piece of legislation that we are looking to pass this evening in terms of alternative dispute resolution in the name of arbitration. And he spoke also with authority, and this crosses over to a point made by the member for Chaguanas West, the importance of confidentiality. The member for Chaguanas West spoke to it as well. The importance of confidentiality in the energy sector. It is not that the government of Trinidad and Tobago is looking to hide secrets or to have secrets or to hide anything from the population. But when you're out there in the real world and you are dealing with international players and they are sensitive to the direct international competition that they have to engage in, confidentiality is an important, very important litmus test in the capacity of international investors to be able to come to your country and to say, we can confidently do business with you because our trade secrets and other confidential information will be protected. And therefore, if in a dispute resolution process, we can promise them with our UNCITRAL-based legislation, the Arbitration Act of 2023, which is what this act will be called when this evening I hope we pass it into law, we will be able to say with confidence to potential foreign investors, your confidentiality will be respected, not by way of keeping secrets from the citizens of this country, but by enriching them for the future lives of their children and their children's children. So I'm grateful for the support that I've had from my colleagues on the government side, and of course, I acknowledge the contributions from member for San Fernando West, Honorable Al-Rawi, who is the predecessor in the office which I now have the privilege to serve in, and I acknowledge and I thank him for the considerable work that he's done to enable me this evening to bring this bill before this House, and I particularly wish to associate myself with the recognition that he's given publicly to the names that he's called, Mr. Dennis Gurley, Senior Counsel, and Salma Rahman, who have made invaluable contributions. And of course, it would be remiss of me if I did not, and I will come to that name in a little while. It will be remiss of me if I did not acknowledge one other name, but I will get there in due course. Madam Speaker, I also want to acknowledge the contributions of the Honourable Member for Mearu. He made some significant, in my view, contributions in terms of the acknowledgement and the support that I understood him to have uttered in response to this bill that is before us. There are aspects of his contribution, of course, which I don't share, but that is not to take away from the areas in which I am grateful for the support. So, for instance, the fact that he was able to speak to the desirability of specialized commercial courts. That is something that this government is working towards, because and when I was speaking earlier today on the other efforts that this government is making in other areas of the improvements in the justice system, we are committed to not only in that other area that I was speaking to earlier, improving our criminal justice system, but also our civil justice system, so that it is entirely compatible with the arbitration bill that we have before the House this evening, that in due course we will be looking to come back to this country and to the citizens of this country to speak to strides that are expected in terms of developing specialized commercial courts. The honorable member for Miaro also made an interesting comment in relation to CARICOM and the revised Treaty of Chaguaramas. And I acknowledge the contribution in that regard as well of the member for San Fernando West, my good friend, the honorable member for San Fernando West, who made an interesting tribute, which is very apt, and I'm grateful to him for reminding me that next week we are celebrating the 50th anniversary of CARICOM. And that takes me back to the comment made by the honorable member for Miaro, who spoke to the possibility that perhaps, and I hope I don't misquote him, that perhaps we could look to addressing the CARICOM revised treaty to enable us to get into more arbitration. Well, the reality is, as we celebrate the 50th anniversary of CARICOM next week, that Chapter 9, Dispute Settlement, Article 223 of the CARICOM Revised Treaty of Chaguaramas, signed right here in Trinidad and Tobago, states at 223, sub-article 2, each member state, with your leave, Madam Speaker, I quote, each member state shall provide appropriate procedures in its legislation to ensure observance of agreements to arbitrate and for the recognition and enforcement of arbitral awards in such disputes. So our revised Treaty of Chaguaramas, signed right here in Trinidad, which gave birth to CARICOM, celebrating appropriately its 50th anniversary next week, has always invoked for us, the citizens of CARICOM, the step that we are taking today to bring this revised UNCITRAL model law onto our law books, consistent with, as I said in my pilot, the desire, the dream, and the vision of the late Honorable Prime Minister Patrick Manning. So I acknowledge that. And if I may then come to one final point in my wind-up, Madam Speaker, and it is to acknowledge the remarkable resourcefulness, and I say this almost every time I stand here to speak to the legislation that I have the privilege to pilot, the resourcefulness of the team out of the Office of the Attorney General and Ministry of Legal Affairs that I have the privilege to lead. And I got from that lady, that very lady that Honorable San Fernando West member mentioned, Ms. Nirana Parsan, and a WhatsApp, literally as I was sitting here, that provided me with some material that I am going to close with. Ms. Parsan is head of process review. She has been the one who has been leading the work that has supported me in bringing this bill to the Parliament, of course, ably assisted and supported by the Chief Parliamentary Counsel's department. I received from her at about 6 p.m., 7 p.m. this evening, an article, a blog dated April 2022, Thomson Reuters Practical Law Arbitration blog by Akima Paul Lambert, partner in Hogan Lovells. And I hope you will forgive me, Madam Speaker, and my friends will forgive me if I quote at some length from this article, because it is so apt. April 2022, it is so apt to everything that we are saying here today, and is a recognition from outside of Trinidad and Tobago of the ethos and the purpose of what we are about here. So the article begins with a reference to a previous article written in 1994, in which that previous article had highlighted the limited success of commercial arbitration in the commercial region. And then the article says, the causes of these early failures, and I quote, Madam Speaker, the causes of these early failures, that is to say, the failure of the Caribbean community to take advantage of arbitration, were attributed to a combination of cultural apathy in the concept of arbitration. It appeared as if Caribbean citizens wanted their quote-unquote day in court, general resistance to the harmonization of arbitration legislation, and perceived disinterest by the business community. And then it continues. However, recent developments, again I quote, recent developments demonstrate that dispute resolution services in the Caribbean region are demanding faster and more flexible mechanisms to resolve their disputes. A renaissance for international arbitration in the Caribbean is on its way. There have been recent efforts by stakeholders to encourage the growth of arbitration in the region, and the article cites the CARICOM impact justice work that I have cited in my pilot, and is cited throughout the work of the bill that is before the Parliament today, because it is modeled off of that bill, is modeled off of the CARICOM justice impacts model law on the UNCITRAL law. And the article says the impact of this, that is to say, the recent efforts by stakeholders, the impact of this cannot be overstated. And I quote last this paragraph, so pertinent to what the Minister of Energy and Energy Resources was saying earlier. Recent changes and potential transformations in the energy sector are also likely to have an impact on the choice of dispute resolution. The Caribbean has already seen a spate of international investment disputes, notably in the energy sector, and we are likely to see more. Guyana is mentioned, and then it concludes. Also, the impact of alternative energy transitions should not be understated. The Caribbean is heavily impacted by climate change and is poised to be the beneficiary of climate mitigation funding. If disputes arise in relation to the implementation of any transactions relating to climate or alternative energy, parties will look for a dispute resolution process that is efficient, location neutral, and where parties have influence over the composition of the tribunal. Madam Speaker, that is an April 2022 article speaking to the very business that we are about in this House today, and recognizing the sea change that has occurred in the Caribbean, which Trinidad and Tobago is now committing to in the very piece of legislation that we ask you to, I ask my colleagues in this House to join with me on in order to pass this into law. With the greatest of respect, Madam Speaker, I beg to move.
Honourable members, the question is,